Hello students and welcome back to Political Science 1513, American Federal Government Online. As always, I'm your instructor, Connor Alford, and in this week's lecture, we're going to talk about some of my favorite topics. We're going to discuss natural rights, both positive and negative, what they are, where they come from, and how they have historically been treated in the United States. Towards that end, we have 5 major learning objectives that I would like you to focus on as you begin to take your notes while listening to this lecture. Learning objective number 1 asks for you to distinguish between natural rights, and civil liberties. Learning objective number 2 asks for you to explain the relationship that our civil rights and civil liberties have to the Constitution and the courts of our country, and how this relationship has changed over time. Learning objective number 3 asks for you to discuss the purpose and importance of the First Amendment and how the court has addressed it over the years. And learning objective number 4 asks for you to explain the equal protection doctrine, who it protects and where. Finally, we have learning objective number 5, which asks for you to explain the content, impacts, and significance of the 3 Civil War amendments. All right, so let's go ahead and get started with that first learning objective. Let's talk about natural rights, positive and negative. What are natural rights? What types of natural rights are there? And how are these different types distinct from one another? Where do they come from? And how are they protected? How has the law on our rights evolved in the United States over time? These are all questions that we can begin to answer only after we understand the concept of a natural right. So what exactly are natural rights? Well, natural rights are universal rights that individuals possess by their nature as human organisms, rather than by law or convention. So there are a few key points embedded in this definition that you need to pay attention to. So first off, understand that natural rights are universal. They are held by every member of the human family without condition or qualification of any kind. This includes conditions and qualifications pertaining to race, gender, sexual orientation, religion, political affiliation, country of origin, ethnicity, so on and so forth. Every member of the human family, every living human organism, every organism of the species Homo sapiens is automatically, innately, and inalienably entitled to the same set of universal rights. If this sounds familiar to you, it's because these ideas are also enshrined into modern international human rights law by a document that I've asked you to read, the 1948 Universal Declaration of Human Rights, which you probably know was written shortly after the Second World War by the United Nations, which at that time was largely led by the United States. So one thing that we're going to discover is that this idea of natural rights, which entered into our country very early on during its founding era, has since been exported to pretty much the entire world. But let's not get too sidetracked with the big picture of the globe as a whole, because this is an American government class. So first, understand natural rights are sometimes called human rights, and that's because they are universal to all humans. You also need to understand that natural rights are individual rights. They don't belong to countries, they don't belong to race groups, they don't belong to religious denominations, they don't belong to cities. They belong to you and me, to individual human organisms, to particular persons. They don't belong to white folk or to African Americans. They don't belong to men or women. But they do belong to Bob and Sue and Joe and Rashawn and Miriam and so on and so forth. Next, you need to understand that, again, these rights come from your nature as a human organism. It is innate to human nature to have certain freedoms. And when governments and other actors begin taking these away through institutions like slavery, rape, oppression, murder, so on and so forth, this is an unnatural occurrence. It is a deviation from the will of nature and nature's God to utilize some of the language that might have been bouncing around at about the time that our country's founding documents were being written. Finally, they are, again, going to come from your nature as a human, not, and this is a key point, not from any law, document, or convention. So one common mistake that people often make is to claim that the Constitution of the United States gives you your fundamental rights, and that's not true. The Constitution doesn't give you your natural rights. Those come from your nature as a human. You already have them. And whether you are an American who lives under the authority of the U.S. Constitution or a North Korean who does not, you are entitled to these same natural rights, which is important. Because if we accept that these natural rights are universal, that they come from nature and not from any particular legal document or country or tradition or convention, then this means that all governments around the world are morally obligated to respect them. And therefore, we can distinguish between good and just government on the one hand, bad or unjust government on the other hand, primarily based on the extent to which each government respects individual natural rights. When governments are collectivist, when governments are ignoring the rights of individuals, when they are oppressive, when they are murdering, raping, enslaving, so on and so forth, we say that they are unjust. But when they respect our natural rights, when they abstain from these grotesque crimes, we say that they are just. The theory of natural rights really emerged in Europe during the Enlightenment. But it was popularized by this guy named John Locke. And if you've done your reading through the semester, you know that John Locke is critically important to American history. He's sort of an honorary founding father of the United States because his ideas were so influential to the framers of our Constitution, to the founders of our country, and especially to Thomas Jefferson, who wrote the Declaration of Independence, that those ideas became embedded into our very way of life. And then they were exported by us after the Second World War through the Universal Declaration of Human Rights to virtually every other country around the world. So understand, we are a fundamentally Lockean society. And this is important because no thinker, no philosopher, at least that I'm aware of, has ever made natural rights a more critical part of his political theory, of his ideas about human society, than John Locke. However, at this stage, I think I've raised a bit of a question. If our civil rights and liberties, if our natural rights do not come from the Constitution of the United States, why do so many people make the claim that they do? Where does this confusion come from? And why do we need to talk about the Constitution to understand the history of civil rights and civil liberties, of natural rights for the United States? Well, the Constitution might not create your natural rights. It might not give you your natural rights. It might not be the source of your natural rights, but it is their primary protector. I want you to understand that while the Constitution doesn't create natural rights, it does create legal protections for and recognition of those rights. The Constitution of the United States is a monumentally, historically revolutionary and important piece of literature, piece of legal documentation, in large part because this is the first time a national charter codified our natural rights into law. And therefore, it continues to be relevant today because the Constitution is the source of the general protections for our natural rights that we continue to enjoy in the American legal system. Do keep in mind, however, that the Constitution, which you will recall from prior lectures was written centuries ago, tends to focus primarily on a particular type of natural right called the civil liberty. The Constitution tends to emphasize freedoms over entitlements, and that's something that's important to keep in the back of your mind. It's also important to understand that the Constitution only creates legal protections for our civil liberties in very broad and general terms. It tends to be quite vague. So, for instance, it will tell us that we have a freedom of speech, but it doesn't tell us how far that freedom of speech extends, what limits are attached to that freedom of speech. We tend to recognize that there are limits. Even the framers seem to recognize that there were limits to free speech. At no point in our history, for example, has it been acceptable for an individual to walk into a crowded movie theater and shout "fire" unless there was actually a fire. But that is literally speech. Shouting the word fire is using your power of speech in a very literal way. So how do we know that that's not protected by the First Amendment freedom of speech? Conversely, today we tend to understand that my freedom of speech extends not just through my lips, but through my keyboard. If you want to go onto your Facebook and make a post sharing an opinion about the government, we generally understand that that is a form of protected political expression under the First Amendment. But the Constitution never says anything specifically about Facebook. So how do we know that this general freedom of speech, broadly protected by the Constitution, applies to Facebook posts but not to shouting movie theater in a crowded fire? Well, we know these things, for the Supreme Court tells us so. And this is why the courts are relevant to our civil rights and civil liberties in a legal sense. While the Constitution provides the big picture, the general protections for our civil rights and liberties, our natural rights, I want you to understand that the Supreme Court of the United States and the lower courts in our country are responsible for taking these big pictures and helping us to figure out how they apply to particular cases or controversies. So the courts then are important because they provide the particular protections for our civil rights and civil liberties. But there are also some other points that we need to make. Number one, while in theory, courts are supposed to be the protectors of civil rights and civil liberties, of the various types of natural right, historically, they've got a very mixed record. I want you to note that the courts have been both the primary opponent and the primary protector of human rights in our country. It ruled, for instance, against the Indian removal. But it also upheld racial segregation and laws that forced people to participate in racial segregation against their will. It upheld rulings that allowed FDR to unilaterally take an entire ethnic group in the United States and on the basis of their ethnic identity imprison them in internment camps in the case of Korematsu. So, yeah, the Supreme Court has done a number of great things to protect our individual liberties and our human rights. But at various times, it's been a very poor protector, and at other times, it's been an active opponent to civil rights and civil liberties. So that complicates the historical record, if not the theoretical practice. I also want you to understand that while the Constitution, in its strictest sense, emphasizes civil liberties, the Supreme Court and the other courts of our country have tended to focus more on another type of natural right that the framers of our Constitution didn't tend to think about or talk about. And that's going to be the civil right, the positive right. So I want you to understand at this stage that, generally speaking, in modern constitutional law, we can identify two different types of legally protected natural or human right. These two different types of rights are sometimes called civil liberties and civil rights. A civil liberty is a natural right protecting us against government action. Civil liberties are freedoms that the government cannot violate, but that it doesn't necessarily have to help us exercise. Examples include the freedom of speech or the right to remain silent. We do have a natural right to keep our mouth shut, but if you choose to speak, that's not the government's fault. In order to respect your civil liberties, the government simply has to abstain from taking them away from you. It doesn't have to help you speak your mind, it just can't censor you if it doesn't like your opinions. So one way to think about civil liberties is to understand that these are a type of natural right, but that these particular natural rights are protected in our Constitution through a series of prohibitions against government actions. Civil liberties, in other words, are natural rights which tell us what the government cannot do to us. The other major type of natural right that we can discuss is the civil right. And civil rights are basically goods or services that you are entitled to receive, or actions, affirmative, active actions that the government must take on your behalf, things that the government must do for you, usually in the interest of ensuring equal conditions, equal opportunity, and, depending on who you ask, perhaps even equal outcomes in the economy. Some examples of civil rights that you might know of come from the idea that you have a right to an attorney. You've probably heard the Miranda rights. You've probably heard it read on crime shows. If you cannot afford an attorney, one will be provided to you. You have a civil liberty to be an attorney. If you want to be an attorney, well, You have a right to do so, but that doesn't mean that the government has to help you pass the bar exam or pay for your law school. It simply means that it ought not interfere. It shouldn't prevent you from becoming an attorney just because it doesn't like you. You should have the freedom to choose your career, but that doesn't mean that other people have to help you achieve your career goals. Whereas you have a civil right to an attorney. If you can't afford an attorney, the government must give one to you. It must ensure that you receive the active good or service of legal counsel. So if civil liberties tell us what the government cannot do to us, civil rights tell us what it must do for us. If civil liberties are about freedom, civil rights are about equality. If civil liberties prohibit government action, civil liberties mandate government action. If civil liberties limit the size of government, civil rights expand the size of government. The language of civil rights and civil liberties, however, can sometimes become confusing for students. And the reason that students are sometimes confused by the language of civil rights versus civil liberties is that many of the things which we call rights in the Constitution are actually liberties and not civil rights at all. Now, remember, the idea of a civil right, a positive right or entitlement, didn't really exist at the time that our Constitution was being written. At the time that our Constitution was being written, people didn't distinguish between civil liberties and civil rights. They just talked about natural rights. So, for example, the Constitution of the United States in the Second Amendment talks about the right of the people to keep and bear arms, which basically means that the government cannot come and take people's firearms away from them. It cannot disarm the public. It cannot disarm law-abiding citizens or strip them of their firearm property without due process of law. If you commit a crime with your gun, that's one thing, but basically the Second Amendment says, government, you shall not take people's guns away. They shall be free to keep and bear arms as long as they're doing so in a lawful manner. This is a civil liberty. It creates a prohibition on government action. If you were to say that you have a civil right to keep and bear arms, then it wouldn't be enough for the government simply to abstain from taking your guns away. It would actually have to provide them to you. If you cannot afford a gun, one will be provided to you, right? Well, wrong. No, if you can't get a gun on your own, that's your problem. The government doesn't have to provide the gun. So again, this is a civil liberty, not a civil right. But if the right to keep and bear arms is a civil liberty and not a civil right, why didn't they say so? Well, because again, that distinction, this language, didn't really exist at the time. And therefore, when they say rights, they are often meaning civil liberties, and they never really talk about civil rights by name, not in the Constitution. So to help clear up some of this confusion, I'm going to introduce you to a couple of common synonyms for the terms civil rights and civil liberties. Understand that civil liberties are sometimes called negative rights or freedoms. They are sometimes called negative rights because they create a negative duty, a duty of non-intervention, a duty to abstain from action. In other words, a negative right is something that tells us what the government cannot do to us or cannot take from us. And that's why they're called freedoms, because these are freedoms that we naturally enjoy, that we can exercise on our own, things like expressing our opinions and speaking, just so long as the government or other actors don't get in the way. So how do you respect a person's freedom of speech? Simply by abstaining from censorship. How do you violate their freedom of speech, this negative right to express their opinions? Well, you violate it by actively censoring them. So again, civil liberties limit the rightful function of government. They prohibit the government from taking some type of action. And therefore, government is the main threat to civil liberties. Government is the main institution that civil liberties exist to protect us from. Civil rights are different. Civil rights are sometimes called positive rights because they create a positive duty, an affirmative duty, a duty to actively provide some good or service. And that good or service is usually something that not all of us can provide for ourselves, but that leaving some of us without while others enjoy it will create inequality. And again, legal counsel is a really good example of this. If in our country we still treated the right to an attorney as a civil liberty, as a negative right or freedom, where we would say if you can afford an attorney, you're free to get one and I won't stop you, but if you can't, well, tough luck. Then the concern here is that this will create a great inequality in legal outcomes. Rich people who can afford attorneys will get really, really good legal outcomes, and poor people who cannot will have really, really poor outcomes, and therefore the courts have told us in a series of rulings that we must, in the interest of equality, begin to treat the right to an attorney as a positive right. So now if you can't afford one, one will be provided to you. You are, as an American, entitled to receive legal counsel if you wind up in a court of law. So civil rights actually mandate government action. They expand government activity. And therefore, the government is not the main threat to civil rights in most cases, but rather the main facilitator, because civil rights only work by telling the government what it should do. So, to kind of summarize, I want you to understand that your civil liberties, or your negative rights, are basic freedoms and liberties. They are rooted primarily in the Bill of Rights, and they primarily restrict what the government can do to you. So, for instance, Congress shall make no law abridging the freedom of speech tells us what Congress shall not do. It shall not make a law censoring people's speech. Whereas civil rights, sometimes called positive rights or entitlements, are active goods or services that we are entitled to receive in the interest of equality. And basically, in our country, your civil rights boil down to an entitlement to receive government protection from discrimination. Now, I do want you to understand that this idea that you are actively entitled to government discrimination from private actors is never explicitly articulated in the Constitution. Instead, the entire foundations of civil rights law in our country is going to be rooted in the court's interpretation of the Equal Protection Clause of the 14th Amendment. And we'll elaborate on that later, but I just again want you to understand your civil liberties primarily come from explicit protections in the Constitution, whereas your civil rights are going to receive most of their legal protections from court interpretations of a particular part of the Constitution, the Equal Protection Clause in the 14th Amendment. Okay, so now that we know the main difference between civil rights and civil liberties, we can begin to talk about how they have changed over time. So what I want you to understand is that early on in our nation's history, the emphasis of the law was on protecting your freedoms. Pretty much every single right protected in the Bill of Rights, that first 10 amendments to the United States Constitution, was a negative right. In fact, today, it would probably be more accurate to describe the Bill of Rights as the Bill of Liberties because, again, the primary interest of the Anti-Federalists who authored the Bill of Rights and demanded that the Bill of Rights be added to the main body of the Constitution before they would ratify the Constitution, their main interest was in limiting the power of the federal government, telling us what the federal government could not do to us. So your freedom of speech tells us the government shall not censor you. The Second Amendment tells us that the government should not disarm you. Your Fourth Amendment freedom from unreasonable searches and seizures tells us that the government should not begin seizing your property or searching your person without a warrant issued by a court following due process as per the Fifth Amendment. The Bill of Liberties tells us that you should be free to live in your house without the government quartering its soldiers inside of there. So again, early on in our country, there was no real concept of a positive right. There was no notion that there were certain goods or services that you were entitled to receive independent of your willingness or ability to acquire them on their own. Nobody was entitled to the fruits of another person's labor, to the active provision of certain goods and services under U.S. constitutional law. However, today we know that that's not true. I want you to understand that the first major historical trend in the evolution of legal protections for civil rights and civil liberties in our country has been a gradual transition from the early emphasis on freedoms to a contemporary emphasis on entitlements, driven primarily by the United States Supreme Court and lower courts over the years. This transition from our early emphasis on preserving freedoms to our contemporary emphasis on promoting entitlements really originates in the early 1900s, when the United States Supreme Court began to reinterpret the 14th Amendment's Equal Protection Clause. So you probably know that the 14th Amendment is one of the 3 Civil War amendments, and that basically it extended citizenship to newly emancipated slaves after the Civil War had ended. But one really important clause, in fact, one of the most litigated clauses in the entire Constitution, which you're going to find if you read the 14th Amendment, is the Equal Protection Clause, which states that, and I quote, "No state shall deny to any person within its jurisdiction the equal protection of the law." So what this is basically telling us, the courts begin to argue starting in the early 1900s, is that both the federal government and the state governments must actively ensure that people are receiving equal protection from discrimination in certain settings. All right, now understand, when it was first written, the 14th Amendment's Equal Protection Clause was thought of as a negative right. It's telling us what the government shall not do. No state shall deny to any person within its jurisdiction the equal protection of the laws. But given realities on the ground, the courts began to argue in the early 1900s that the equal protection of the law meant that it was not enough for states to simply abstain from discrimination. In certain circumstances, they had to actively intervene to prevent discrimination by private actors on their own. In other words, I want you to understand that starting in the early 1900s, the courts reinterpreted the Equal Protection Clause to create a new legal doctrine, the Equal Protection Doctrine. And the Equal Protection Doctrine tells us that we are basically entitled to receive active government protection from unequal treatment on the basis of certain characteristics. Now, again, as we move forward, I'm going to elaborate on that, but understand that this active government protection from unequal treatment is, in fact, a positive right, because it's not enough for the government simply to abstain from discrimination itself. It must prevent other actors, states, private employers, educational institutions, so on and so forth, from engaging in independent discrimination. That idea is very recent in the grand scheme of things. And again, in our country, it doesn't emerge until after the Civil War, and it doesn't emerge until the early 1900s, but it is going to be couched in, cloaked in, and based on the court's interpretation of the Equal Protection Clause. So that's the first major historical trend. We originally focused on freedoms, whereas today most constitutional law talks primarily about entitlements. Civil rights rather than civil liberties, positive rights rather than negative rights. The other major transition has been what we refer to as incorporation. And this has been a gradual process, but basically I want you to understand that when the Constitution was first written, when the Bill of Rights was first written, it was understood that our civil liberties only applied to the federal government. So for instance, when the First Amendment says that Congress shall respect no establishment of religion, it's talking about the federal Congress. It doesn't say the state shall respect no establishment of religion. It says that Congress, the United States Congress, the federal government, shall not do this thing. A lot of the states did respect establishments of religion. They had official churches. And these types of policies, where you see states doing things like disarming their citizens, were broadly accepted as long as they took place at the state level. And that's what we're going to find in the case of Barron versus Baltimore. I'm not going to go into the details of that case here because you'll get them from your reading and you can look into them on your own. But I just want you to understand that this was a very important early Supreme Court case in which the Supreme Court rightly argued that the people who wrote the Bill of Rights were trying to create limits on federal action, not necessarily on state action, and that therefore the Bill of Rights only prohibited federal government intervention, that the Bill of Rights only protected us from federal violations of our fundamental freedoms. Today, that's not true. Today, if the state of Oklahoma tried to create an official church, people would flip, and the courts would immediately strike that. So clearly something has changed. And that change has been the incorporation of the Bill of Rights against the states by the courts through their interpretation of another piece of the 14th Amendment, the Due Process Clause. The Due Process Clause follows the Equal Protection Clause, adding, "Nor shall any state deprive any person of life, liberty, or property without due process of law." Now, one thing that's interesting about this is that language of depriving persons of life, liberty, and property without due process of law was lifted more or less wholesale from the Fifth Amendment and the Bill of Rights. But unlike the Fifth Amendment, which clearly only talks about the federal government, the 14th Amendment's Due Process Clause says, "Nor shall any state deprive any person of life, liberty, or property without due process of law." So how do we get from this Due Process Clause claim that no state is allowed to deprive somebody of life, liberty, or property without due process of law to the modern system in which the Bill of Rights, the prohibitions on government action, which were originally intended only for the federal government, now also applies to and is incorporated against the states? Well, pretty simple. Starting in the early 1900s, the Supreme Court of the United States decided that due process of law means legal acknowledgement and procedures consistent with our fundamental freedoms. This is what they refer to as substantive due process. Substantive due process is a process of law consistent with your fundamental natural freedoms or civil liberties. So any state procedure, any state action which would strip you of a freedom protected by the Bill of Rights would therefore, according to the Supreme Court, violate the Due Process Clause of the 14th Amendment. Now, I do want to be clear. It's fairly well understood that this is a fairly tenuous line of logic, but it is critically important in a historical sense, because what we're going to understand is that, again, the Supreme Court's interpretation of the 14th Amendment's equal protection and due process clauses is the fundamental cause of the two major historical developments in the evolution of civil rights and civil liberties in U.S. constitutional law. And remember that these two fundamental major historical developments have been a transition from our early focus on freedom to our contemporary emphasis on entitlement, and a gradual incorporation of our freedoms against the states. All right, so now that we've talked about natural rights, positive and negative, in general terms, how they relate to the Constitution and the courts, how they're protected, how they've changed over time, so on and so forth, we can start to look at some specific civil liberties. And in the interest of time, I'm not going to cover every single civil liberty which receives legal protection in the Constitution because, well, this is an introductory level course. That would be a graduate level class, and we just don't have time. So instead, I'm just going to start at the beginning, and I'm going to focus on the First Amendment. In this segment of the lecture, we're going to begin to talk about our associational and expressive freedoms, the 5 freedoms of the First Amendment, which are also sometimes called the 5 fundamental freedoms of democracy. These include, but are not limited to, the freedom of religion and the freedom of speech, and so we're going to talk about each of these as they stand in current U.S. Supreme Court jurisprudence. So, what are the 5 freedoms of the First Amendment, the cornerstones of modern American democracy? Well, these are going to be the freedom of religion, the freedom of speech, the freedom of press, the freedom of assembly, the freedom to petition the government. And what I want you to understand about these 5 fundamental freedoms is that it is generally understood by scholars and political philosophers alike that without these 5 freedoms, you cannot have meaningful democracy. And if you don't understand why you have to have the freedoms of religion, speech, press, assembly, and to petition your government in order to enjoy a meaningful democracy, go back and look at our lectures on elections and campaigns. And remember that if you are going to have an ability to contest the outcome of an election so that you can control your government decision makers and hold them accountable for their decisions, it's not enough simply to do the bare minimum and cast a vote. You're going to have to get together with a bunch of other like-minded individuals, and you're going to have to work with them to get a whole bunch of people to cast votes for your candidate and against the other guy or gal. Therefore, it is important that you have the ability, number 1, to organize, to choose who you associate with under what terms, and to express opinions that the government doesn't necessarily like. So if you look at these 5 freedoms, what you're going to find is that all of them relate either to your freedom of association, things like what religions you belong to or participate in, and your freedom of expression, things like your ability to access media free from government censorship and control, or to speak your mind. And I want you to take a moment, and I want you to ask yourself, why? Why did the framers choose to make these the first freedoms secured with legal protections in our Constitution? Why is the First Amendment focusing on these? Well, because again, the framers are trying to make sure that the people have the ability to do what they just did. When the Constitution was written, it was written by a bunch of people who had just assembled, gotten together primarily in their churches, spoke their minds, used their own printing presses, created their own associations, assembled with their own citizens and friends, and petitioned their government for change, and then eventually, when those petitions were ignored, rose up. And they want to make sure we have the ability to do the same thing. So, suffice to say, the First Amendment is not only critically important, it's excessively comprehensive. I could spend an entire graduate level course talking about nothing but the First Amendment freedoms. However, because again, this is a survey course, I'm just going to focus on some of the big freedoms that you need to understand for the purposes of this class. And what I want you to remember is that one way you can organize or understand the First Amendment is to recognize that the freedoms it protects basically fall into one of 2 broad categories. They either relate to the freedom of religion or to the freedom of expression. And together, these are what allow us to do things like control our government, or if it becomes tyrannical, even overthrow it. So let's talk about what the Constitution has had to say about our freedom of religion, on the one hand, our freedom of expression or speech, on the other hand. We're going to start with the freedom of religion because it comes first in the Constitution. And I want you to understand that when we're talking about the freedom of religion, there are really 2 clauses that you have to pay attention to: the Establishment Clause and the Free Exercise Clause. The Establishment Clause says that Congress shall create no law respecting an establishment of religion, whereas the Free Exercise Clause says, nor shall it make any law prohibiting the free exercise thereof. To translate this constitutional parlance into modern conversational English, the Establishment Clause basically says that the government can't force you to practice one religion, whereas the Free Exercise Clause says it can't prohibit you from practicing another. Establishment Clause, I can't make you join my religion. Free Exercise Clause, I can't prevent you from participating in yours. And these are the cornerstones of religious liberties in our country. But what it means to respect an establishment of religion and how far your free exercise of religion reaches is not clearly delineated or detailed by the Constitution. And so to flesh these general freedoms out, we're going to look at the Supreme Court and what it has had to say about our First Amendment freedom of religion. And we're going to start with Lemon versus Kurtzman. I want you to understand that Lemon versus Kurtzman is the probably most important Establishment Clause case. Lemon versus Kurtzman is an Establishment Clause case. I'm going to give you some background information. I won't test you on this, but very briefly to contextualize the legal debate you need to understand. In the late 1960s and early 1970s, several states, in particular Pennsylvania and Rhode Island, began creating policies that used public tax dollars in order to subsidize private educational institutions. In exchange for this public financing, these private schools agreed to lower their tuition for indigent citizens. So they basically would say, hey, if you will take this money from the state, we'll give it to you, but in exchange, you have to agree not to charge a poor person more than he or she can afford to pay for his or her children to attend your school. The idea was to give indigent Americans more options when it came to the education of their children, and to ensure that poor people in Pennsylvania and Rhode Island had the same access to the same quality of education that rich people had. And to some extent, it worked, but it also raised a lot of eyebrows. It caused some problems, because what we're going to discover is that at that time and still today, the vast majority of private schools in those states, and indeed in our entire country, were Christian schools, are Christian schools. And so what was happening was basically a situation where you had private Christian schools receiving funds from the state, then using those funds to continue their operations, which involved things like leading students in prayer, teaching creationism, and doing Bible study. So some people who were not Christians were upset because they felt that it was unfair that they were being forced to pay taxes, and that those taxes were then being used to teach doctrines that they didn't believe in, and that some of them actually thought were offensive and strongly disagreeable. So they brought a lawsuit asking the states to knock it off. The states ignored it. It went all the way to the Supreme Court. Boom. You get Lemon versus Kurtzman. Okay, so that's the background. Here's what you need to understand. In Lemon versus Kurtzman, the Supreme Court had to decide whether state policies funding private religious schools violated the Establishment Clause. And I want you to understand that in Lemon versus Kurtzman, the Supreme Court said yes, these state laws violated the Establishment Clause of the Constitution and were therefore null and void. But in addition to understanding the ruling in Lemon versus Kurtzman, I want you to understand its reasoning and its significance. So, in order to understand the reasoning, what I want you to know is that the Supreme Court justified this decision by creating what it calls the Lemon Test. The Lemon Test is a judicial standard that we still use today to determine whether a particular government action violates the Establishment Clause. And basically, the Lemon Test tells us that in order to be consistent with the Establishment Clause, a government action must satisfy three conditions. First, the Lemon Test tells us that the government action must serve a legitimate, non-religious state purpose. And in this case, it did. It helped make education more affordable and equal to poor Americans. Wonderful. But in addition, the Lemon Test tells us that the government policy or action must not either prohibit or advance a practice of religion. And in this case, it seems like the policy in question did help to advance certain religious practices and teaching, because the monies being used by these private schools went in part to do things like pay teachers to teach students Bible study and lead them in prayer. Finally, the Lemon Test says that the policy must not create an excessive entanglement between church and state. And the court says that funding private religious schools, which do things like provide Christian instruction, does create excessive entanglement. Now, one thing that you might put down in your notes is that the term separation of church and state never once appears in our Constitution. It's just not in there. But the courts have basically told us that you can infer from the prohibition on respecting an establishment of religion that the framers intended for there to be a certain degree of separation. They recognize it cannot be an absolute degree. Some form of entanglement is inevitable. People are going to use public roads to get to church, synagogue, or mosque, for example. But that there is a point at which you have too much entanglement. And once you start funding private religious actors using public tax dollars, the court says you've crossed that line. Now, I want you to understand that they created the Lemon Test not just for this particular situation, but because they wanted to create a judicial standard which could be used by the courts moving forward in all subsequent Establishment Clause cases. But I want you to understand that the Lemon Test is not very good at achieving its goal. It's meant to help courts figure out which types of government actions are and are not permissible under the Establishment Clause, but that term excessive entanglement is so vague that courts can't agree on how it should be applied, because what one person considers acceptable is excessive to another person, and vice versa. So the primary weakness of the Lemon Test is that it is very vague and subjective, and as a result, we still haven't fully figured out how we're going to handle the Establishment Clause in particular controversies. Well then, what about the Free Exercise Clause? Well, to figure out the parameters of your freedom of religion, I want to talk a little bit about the case of Oregon versus Smith. In Oregon versus Smith, basically the Supreme Court has to review a situation where you have two Native American gentlemen who want to ingest peyote as a part of a legitimate religious spiritual tradition practiced by their tribe and other Native Americans across the country for literally centuries before white folk ever showed up on this continent. So it's not just two guys trying to get high. This is a legitimate religious ceremony. However, it's important to understand that peyote just so happens to be a class 1 hallucinogenic drug under both federal and state law. So in Oregon versus Smith, the Supreme Court has to figure out, does the freedom of religion create exemptions from following laws which happen to conflict with an individual's religious beliefs, practices, or traditions? And what I want you to understand about Oregon versus Smith is first that the court says no. Your religious freedom ends where the law begins. That religion does not exempt you from following rules which just so happen to conflict with whatever you say you believe in. And this is important today because Oregon versus Smith is the same court case that we're going to see actors in government relying on in order to do things like mandate vaccinations or life-saving blood transfusions for children whose parents say that providing these vaccinations or blood transfusions violate their religious beliefs. This case is the same reason that states today are able to do things like prohibit polygamy, even though polygamy, the marriage of one person to multiple partners, is an important part of certain religious traditions. Now, I don't want you to get confused. You do still have a great deal of religious freedom in our country. In fact, you probably have more religious freedom in the United States than anywhere else in the world. However, that doesn't mean you can do whatever you want. It means that if the government creates a law specifically for the purpose of snuffing out a particular religion it doesn't like, the government has gone too far. But if the government creates a law which serves a legitimate state purpose, is not targeted, is not unnecessarily restrictive to any particular religious tradition, and it just so happens to conflict with your religious beliefs, that's acceptable. The law then beats out your religious freedom. So another way to think about this is you can't mutilate the genitalia of your daughter or sacrifice virgins just because it's a part of your religious beliefs. The government has banned murdering virgins not because it wants to discriminate against you for your religious beliefs and practices, but because that's a general problem. It's bad. Don't do it. And it's incidental. In other words, Oregon versus Smith says that if a law incidentally conflicts with someone's religious practice, the law wins. But if it's targeted and intentionally going after a particular religious practice, tradition, or belief, then it is a violation of the Free Exercise Clause. Okay, so that's the freedom of religion. And we're very, 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 very briefly going to talk a little bit about your freedom of speech under current U.S. constitutional law. So, here's what you need to understand. The Supreme Court of the United States has, over the years, told us that speech can, generally speaking, be placed into two broad categories. There's what we call protected speech, and there's what we call unprotected speech. Protected speech basically encompasses any form of political expression. And this includes expression that doesn't necessarily involve literal verbal articulation, like actual literal speech. So for instance, in 1969, we have the case of Tinker versus Des Moines, where a couple of high school students showed up to class one day wearing anti-war armbands to protest our country's continued involvement in Vietnam. They were essentially expelled for wearing these armbands, and they sued, saying, hey, that violates my freedom of speech. Now, the school disagreed. They said, look, we didn't violate your freedom of speech. We are a government actor. We do have to respect your freedom of speech, but you weren't speaking. You weren't saying anything. This isn't a question of free speech. It's a question of dress code. And at this point, the courts had already said that schools can have dress codes in order to maintain discipline and so on and so forth. The students disagreed. They said, because we're wearing this armband, not just as a fashion statement, but to express a political view, it falls within the intended function of the First Amendment, which the courts had already told us was to protect our ability to express ideas from government intrusion by either the state or the federal government. Therefore, in the case of Tinker versus Des Moines, the Supreme Court basically had to decide whether the freedom of speech was broad enough to encompass forms of symbolic speech, like wearing an anti-war armband, or maybe today posting on Facebook or putting a sticker on your bumper. And in Tinker versus Des Moines, the Supreme Court said yes. It said, first off, the freedom of speech doesn't stop at the schoolyard gate. So yes, high school students do have a freedom of speech. But it said, and this is more important for our purposes, the freedom of speech encompasses symbolic speech. It is meant to protect not just your ability to verbally articulate opinions, but to express yourself by other means. In other words, essentially any form of political, religious, moral, or ethical expression is going to be interpreted by the court as protected by the Constitution of the United States after Tinker versus Des Moines. And if you don't understand exactly how sweeping this interpretation is, we can jump forward about 20 years to 1989 and talk about Texas versus Johnson. And in this case, the Supreme Court said that the freedom of speech encompasses even very offensive forms of symbolic expression, like flag burning. Yeah, the Supreme Court said in Texas versus Johnson that flag burning is a protected form of free speech because it sends a very strong political message. And I think we can agree it does definitely send a very strong political message. Now, whether we should allow it on those grounds is a totally different question, but the court says, yeah. I do want you to understand, the court says, look, flag burning is terrible. Don't do it. It's really bad. It is not good. But, however, it says, specifically because the speech is so upsetting and offensive, it warrants First Amendment protection. And you got to think about why that might be. The court reasons that if the First Amendment doesn't protect speech that upsets people, symbolic expression that upsets people, it's not very useful. Because nobody's going to be upset for you for walking out into public and saying, I love kittens, or wearing an armband that says, I love puppies. Nobody's going to be upset if you go out and you burn a Nazi flag. Right? These are all forms of expression that don't need protection because they're not under threat of censorship. But flag burning, precisely because people are upset by it, is under threat of censorship, and so it is only in these cases where people are being upset by what you have to say, by the opinions or expression, or the means you're using to express those opinions, that the First Amendment can be useful. Therefore, they say Tinker versus Des Moines, symbolic speech, yes. Texas versus Johnson, yeah, that means flag burning. But not all speech is covered by the First Amendment. We also have what's called unprotected speech. There are many types of unprotected speech that we could talk about, but we're going to focus on two. The first is going to be speech which is actively dangerous. And to determine whether speech is actively dangerous and therefore unprotected, the Supreme Court tells us in Brandenburg versus Ohio that we need to apply what's called the Brandenburg test. The Brandenburg test is a two-pronged judicial standard used to determine whether a particular instance of speech is protected or not. And the Brandenburg test basically tells us that if speech is, number one, aimed at inciting imminent lawless action, and two, likely to produce such action, that speech can be prohibited in the interest of public safety. So, for instance, it would be acceptable under the Brandenburg test for me to go into the streets and try to convince somebody to assassinate the Prime Minister of Mongolia. Now, I wouldn't do this, but if I wanted to, I would be free to do so under the Brandenburg test. Why? Well, because even though assassination is lawless action, and I'm trying to get you to do so now, imminently, there's essentially zero chance. There is no reasonable probability that anyone's going to listen to me. I might wind up in the back of a paddy wagon on my way to a mental institution, but I'm not going to make the news for having actually convinced you to kill the Prime Minister of Malaysia. Even if you could do so, it's not going to happen. Right? You don't want to. And even if you wanted to, you couldn't. So there's no real threat. Basically, in Brandenburg versus Ohio, the court is saying you can't censor speech just because it's offensive or because the government thinks that it might one day become dangerous. It has to, number one, actually be immediately dangerous. And number two, it has to be real danger, not hypothetical danger. So Brandenburg test. Speech is unprotected if it is dangerous, and it is dangerous if, number one, it is geared at inciting imminent, immediate, lawless action, and, in addition to that, number two, it is likely to produce such action. The other form of unprotected speech we're going to talk about is obscenity. And again, there are a couple of cases we could talk about, but I'm going to focus on Miller versus California. Because before Miller versus California, we basically don't have a clear understanding of how to define obscenity. We have a case called Jacobellis versus Ohio, where the Supreme Court notoriously said that pornography or obscenity is, and I quote, "I know it when I see it." Right, so I can't give you a definition. I know that it's not protected by the First Amendment. I can identify a particular instance of pornography or obscenity, but I just don't know how to tell other people how the term should be defined. Miller versus California attempts to correct this, and it's going to do so by creating a new test called the Miller test. The Miller test is a three-pronged judicial standard used by the courts after Miller versus California in order to determine which instances of speech qualify as obscenity and therefore do not qualify as protected speech. And the Miller test basically says that in order to determine whether or not a particular form of speech is obscene, we must ask first whether the average person applying current community standards finds that instance of speech taken as a whole appeals to prurient interests in sex. In other words, if it violates the community standards held by the average person and has a prurient interest in sex. Second, the court has to ask whether that instance of speech depicts or describes sexual conduct in a patently offensive way. And then finally, the court has to figure out whether that instance of speech, taken as a whole, lacks any real literary, artistic, political, or scientific value. So, Nicki Minaj fans, I'm sorry, but clearly your taste in music is not protected speech because it's obscene and stupid. And it has absolutely no literary, political, or artistic merit. And you can fight me if you disagree. Go listen to a car alarm. Anyway, so here's the point that I'm getting at with this. Miller versus California is used to determine whether speech is obscene, because the court has told us that the First Amendment is there for the purpose of protecting the marketplace of ideas, making sure that we have the ability to speak our minds, to share our political views with the world around us, and access political views that aren't controlled with the government. The First Amendment is not there to help us peddle pornography. So obscene content can be censored on the grounds that it is obscene, that it's pornographic, but only if that particular instance of speech does not have any literary, artistic, political, or scientific merit, does have a prurient interest in sex, does violate the average person's community standards of morality, and, taken as a whole, does in fact present sexual conduct in a patently offensive way. If it fails to satisfy the conditions of the Miller test, speech is obscene and can therefore be censored. So this is basically why the government has the freedom to do things like prohibit you from sending pornography to people's mailboxes or putting porn on the Disney Channel. Miller versus California is significant because it establishes the Miller test, and the Miller test is important because this is still the test we use to distinguish between obscene and non-obscene speech. I do want to briefly note that the Miller test has the same problem as the Lemon test. It's really, really vague and subjective, right? Who gets to determine whether or not an instance of speech has literary, artistic, political, or scientific value? Right? Because if you ask me, the Twilight novels don't have any literary, artistic, political, or scientific value, and yet all three of those books were bestsellers. So clearly a lot of people disagree. They're wrong, but they disagree. There is one slight final point that I'll just briefly touch on. Commercial speech, right? Speech geared directly and entirely on facilitating a financial or economic transaction, things like advertisements, is considered protected speech under current Supreme Court jurisprudence, but it receives less protection than general political expression. I won't get more detailed than that. Just understand it is out there. Okay, so now we can try to wrap up by talking about civil rights. We've looked at natural rights, positive and negative, the distinction. We've looked at some particular civil liberties. Now let's talk a little bit about civil rights in U.S. Supreme Court jurisprudence and under the constitutional law system of our country today. The most important thing to know about civil rights law in our country today is that it is based almost entirely on what scholars call the equal protection doctrine. And the Equal Protection Doctrine basically says that we as citizens of the United States are legally entitled to be protected from unequal treatment on the basis of certain protected characteristics such as race, gender, or disability, and in certain protected settings such as the workplace, public facilities or services, and education. Now, it is important to understand then that there are limits to your entitlement to be protected by the government from unequal treatment. First off, your entitlement to be protected from unequal or discriminatory treatment by the government is limited to discrimination on the basis of race, gender, or disability. Now, there is currently a great deal of discussion and some action being taken to add to this list of protected characteristics other characteristics. Things like your gender identity or your sexual orientation may soon be on the list. But right now, current law primarily focuses on protecting people from discrimination on the basis of their race, gender, or disability. So, can an employer fire you for getting a tattoo on your face? Oh yeah, absolutely, because tattoos are not a protected characteristic. People with tattoos are not a protected class. And if you don't know, a protected class is just a group of people defined by a protected characteristic. So African Americans are a protected class because that is a race group. Women are a protected class because that is a group defined by its gender or sex. People who have disabilities, they are protected from being discriminated against on the basis of those disabilities. However, not only can we say that the Equal Protection Doctrine is limited to the characteristics which it applies to, but it is also limited in the settings where it applies. So first thing you need to understand about the Equal Protection Doctrine is that it protects individuals from unequal or discriminatory treatment on the basis of race, gender, or disability. But the second thing you need to understand is that it only applies in certain settings. Under current Supreme Court rulings, those settings are the workplace, public facilities, and education. What does this mean? Well, it means that you cannot be fired on the basis of your race or paid less on the basis of your gender. You cannot be dismissed from your workplace or your occupation because you're disabled. And if you are a disabled person trying to access a public building, well, that public building does have an obligation to make reasonable accommodations to ensure that it is just as accessible to you as it would be to anyone else. The most common example of this is that public buildings are required to have wheelchair ramps so that paraplegics and other individuals in wheelchairs are able to access them, the same as individuals who are able to walk and who are not in wheelchairs. But these protected settings don't cover many places where unequal treatment can occur. So for instance, you're going to find that the private home, the bedroom, neither of these are on this list of protected settings. Neither of these is mentioned in current Supreme Court jurisprudence. And what that means is that legally speaking, there is no reason why somebody cannot discriminate against you on the basis of your race or your gender or your disability in those areas. So if somebody says, I'm not going to allow you into my home on the basis of your race, gender, or disability status, well, that person's a jerk, they're a schmuck, you probably shouldn't be friends with them anyway, but they are within their rights. They do have the ability to do that, and you are not, under current law, protected from that form of discrimination. If somebody says that they're not going to sleep with you or date you because of your gender, they are within their rights. And you cannot call that a civil rights violation because the bedroom, sexual relations, don't fall within the list of protected settings. Bottom line then, the Equal Protection Doctrine says that you are entitled to be protected from unequal treatment based on your race, gender, or disability in the workplace, public facilities, or education. But outside of those settings, you are not protected from discrimination, and even in those settings, you are only protected from discrimination on the basis of those characteristics. So let's move on then, and let's begin to talk about where these civil rights come from. Like where did the Equal Protection Doctrine originate? Well, I've already told you that it comes primarily from the Supreme Court's interpretation of the 14th Amendment's Equal Protection Clause. But, where did that come from? How did that pop up? Why was this something necessary? Well, to answer this question, we got to travel back in time to a period just before the American Civil War, when you get the United States Supreme Court case of Dred Scott versus Sanford. And what I want you to understand about Dred Scott versus Sanford is that in this case, the United States Supreme Court ruled that slaves and their descendants, that Africans brought over to this country for the purpose of servile labor, and anyone whose lineage traces back to those African Americans, are property and not persons. In this case, the Supreme Court prohibited states and the federal government, Congress, or other government agents from creating any policy or taking any action which would either abolish slavery in a territory, state, or nationally, or emancipate slaves. And as a result of this, we find that prior to the American Civil War, African Americans are not only enslaved, but they are actively denied any form of civil rights or civil liberties. And indeed, the court is not only going to refuse to recognize, respect, or protect the natural rights, civil liberties, and civil rights of African Americans, it's actually going to actively participate in their oppression by creating legal protections to ensure that slave owners can continue owning slaves and that nobody else can interfere with their ability to do that. So you got to understand, Dred Scott versus Sanford basically says that slaves are property. They don't have any rights whatsoever. And therefore, any black person, even if they have been freed, even if they've escaped a slave state and gone to a free territory, is fundamentally denied recognition as a person before the law. And if you don't understand why that's problematic, well, first off, you got some problems, but second off, go back and read that Universal Declaration of Human Rights. So in order to address this horrendous issue, we have a horrible civil war, the bloodiest war in American history. Hundreds of thousands of U.S. citizens are killed in direct combat casualties alone. But at the end of it, we begin to make some progress through a series of 13 amendments to the United States Constitution. These are the 13th, 14th, and 15th Amendments. Together, these three amendments are called the Civil War Amendments because each one was passed more or less immediately after the Civil War and in order to address certain issues that came up either during or after the Civil War. The 13th Amendment addressed slavery. It abolished slavery. It said that our country will no longer recognize, protect, or accept, even tolerate slavery. So the 13th Amendment abolishes slavery. The 14th Amendment came a few years later, and it provided the first constitutional definition for the term citizenship. And the important thing about this definition of citizenship in the 14th Amendment was that it was intentionally written to be broad enough to encompass newly emancipated African Americans and their descendants. In other words, the purpose of the 14th Amendment Citizenship Clause is to keep states and the federal government from discriminating against people, denying people fundamental rights or freedom because they had been in slavery at one point in their life or because they descended from people who had. In other words, this is the Congress, which authorized the 14th Amendment, trying to undo the Supreme Court's ruling in Dred Scott v. Sanford. In addition to the Citizenship Clause, however, remember the 14th Amendment also contained the Equal Protection Clause and the Due Process Clause, and that these taken together were used by the courts to incorporate the Bill of Rights against the states, that's due process, and create the Equal Protection Doctrine, which is the foundation for all civil rights law in our country today. That's the Equal Protection Clause. Then finally, we get the 15th Amendment, and this pertains to racial discrimination in voting laws. Now, I want to be clear. The 15th Amendment does not create a right to vote for African Americans or anyone else. People often claim that the 15th Amendment gave black people the right to vote. It's not entirely true. Actually, what the 15th Amendment actually did was prohibit racial discrimination in voting laws. In other words, it doesn't say there's a right to vote. But it does say if a state allows white folk to vote on who their governor is going to be, they have to extend that same privilege to African Americans. They can say nobody's allowed to vote, but they cannot say this race group is allowed to vote, but that race group is not. So 13th Amendment, no more slavery. 14th Amendment, redefines citizenship, due process, and equal protection. 15th Amendment, no racial discrimination in voting laws. So that solves the problem, right? Well, no, not quite. Because what we're going to discover is that even after these three amendments are passed, states and private actors alike continue to find ways to get around the Equal Protection Clause, to get around the 15th Amendment. Things like literacy tests, which were administered in very discriminatory manners through the grandfather clauses that your textbook talks about, poll taxes, and so on and so forth. Disenfranchised black voters, kept them from being able to participate fully and equally in the democratic process. And those are not going to be addressed until the mid to late 1900s. And you get a series of discriminatory policies passed across the country called the Jim Crow laws. And these were discriminatory policies designed to disenfranchise African Americans, to cut them off from participating in society or advancing the socioeconomic ladder through legally mandated segregation or separation of the races. The Jim Crow laws, I want you to understand, came in a number of different forms. These Jim Crow laws, for example, often took the form of an anti-miscegenation policy. If you don't know, an anti-miscegenation policy is a law prohibiting racial interrelations. So sexual relationships or marital relationships between white and black partners, being the primary culprits, were fundamentally prohibited in most states through a substantial portion of our country's history. Businesses and public gathering places, government facilities, and educational facilities were also told that whether they liked it or not, they had to discriminate. They had to segregate by race. They had to create separate facilities for whites and blacks, or really whites and anyone else. And these problems, again, they were very intransigent. They were very hard to get rid of. And it wasn't just the states, by the way. The federal government played its own role. It took part in this process. So in the 1896 Supreme Court ruling of Plessy versus Ferguson, for example, you have this gentleman on the left-hand side of your screen, a guy by the name of Homer Plessy, who was 1/8 black, and who was recruited by a group of New Orleans citizens and a private railroad company called the East Louisiana Railway Company to challenge a Louisiana state law mandating separated rail cars for white and black passengers. Right? Private companies didn't necessarily want to participate. Some of them did, were actively excited for the opportunity to discriminate. But many private companies saw this as an unfair, discriminatory, and economically burdensome practice and therefore decided to resist. And so they worked together with a group of citizens to convince a man who is 1/8 black, whose skin is lighter than mine, to board an all-white train car, even though he was 1/8 black, even though legally he was African American. Well, he got arrested when he refused to vacate the white-only passenger car, and so he filed a lawsuit. This goes to the Supreme Court, and the Supreme Court creates a legal fallacy. It creates a legal myth called the separate but equal doctrine. And the separate but equal doctrine basically says that racial segregation, compelled, mandatory racial segregation enforced against the will of private citizens, was perfectly constitutional because separation did not necessarily create inequality. The facilities, the Supreme Court falsely argued, were of approximately equal quality even though they were separate. And so they said, we consider the underlying fallacy of the plaintiff's argument to consist in the assumption that enforced separation of the races stamps the colored race with a badge of inferiority. In other words, separation is not necessarily inequality and therefore does not necessarily violate the 14th Amendment's Equal Protection Clause. That's the Supreme Court's decision, and it's not really going to be revisited for about half a century. But in the mid to late 1900s, we do start to make progress. In the case of Loving versus Virginia, for example, the Supreme Court is going to deal with a lawsuit in which Mildred Jeter, a black woman, and her husband, Richard Loving, go to Washington, D.C. to get married, and then return home to Virginia, where anti-miscegenation laws prohibit interracial marriage. And as a result, the two are going to be arrested and sentenced to serve jail time. They file a lawsuit claiming that this violates their rights. And the Supreme Court agrees. It says, under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the states. In other words, the government needs to get out of the way of individuals under the 14th Amendment's Equal Protection Clause. In 1954, we get another case, Brown versus Board of Education. See, at the time of the Brown versus Board of Education ruling, over 1/3 of all of the states had segregated their public schools by law. And the District of Columbia had also done so, making this both a state and federal issue. But in this case, the Supreme Court decided to partially overturn its ruling in Plessy versus Ferguson. From the unanimous opinion, we get this quote. The court concludes, that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we hold that the plaintiffs and others similarly situated are deprived of equal protection of the laws guaranteed by the 14th Amendment. In other words, what the court is telling us is that legally mandated de jure segregation of public schools violates the 14th Amendment. But the problem is not yet resolved because you still have de facto racial segregation in fact, and you still have most of those Jim Crow laws still being enforced under the doctrine of Plessy versus Ferguson, right? Because Brown versus Board of Education doesn't overturn Plessy versus Ferguson, contrary to what you might have heard. It simply says that the doctrines of Plessy versus Ferguson do not apply to public education. But private schools and private businesses, well, those can still be separate but equal. So it doesn't resolve all the problems. And even where it does help take a step in the right direction, it's not legally enforced and carried out at the state and local level. Because those voting barriers, the poll taxes and literacy tests that we talked about before, are still keeping African American citizens from being able to participate in the democratic process by electing decision makers who will choose to create policies consistent with the Supreme Court's decisions. And many people, they call for the Supreme Court to go a step further, but it's largely reluctant to do so. And so actions are going to have to be taken by other actors. Therefore, Brown versus Board of Education, I want you to understand it is a step in the right direction. It is some legal progress. It does partially overturn Plessy versus Ferguson. But it's most significant for its historical impact because Brown versus Board of Education helped to initiate the civil rights movement of the 1950s and 60s, which got the government to begin applying the equal protection doctrine to the equal protection of African Americans. It was Brown versus Board of Education in 1953 that inspired Rosa Parks to refuse to give up her seat to a white man in a whites-only section on a bus. And when she was arrested, this in turn inspired a series of Montgomery bus boycotts that were organized by a Baptist reverend you might know as Martin Luther King Jr. The success of the Montgomery bus boycotts was so shocking that it elevated Martin Luther King Jr. to national acclaim. He became a national figure, and he was able to use this national visibility that he never would have enjoyed without Brown versus Board of Education to lead a march on Washington, D.C., where he gave the "I Have a Dream" speech. And yet, legally speaking, problems persisted. So, after Brown versus Board of Education, we get the Civil Rights Act of 1964, which is basically going to overturn most of the remaining Jim Crow laws for private schools, businesses, and public gathering places. And just as importantly, it's going to enforce desegregation of public schools by mandating racial integration. So this is where you start to hear about the bus boycotts, the busing of African-American students into formerly all-white schools. The schools basically gerrymandered their school districts to keep their student base almost entirely white. And in order to address this, Congress mandated that these cities where this was happening begin taking active steps to ensure not just desegregation, but active integration of the races, so that de facto segregation would go away. And by the way, this still comes up as a contentious topic in modern American politics. During the 2020 presidential elections, for example, sparks flew when Kamala Harris would the future vice president, Kamala Harris, criticized the future president under whom she would serve. She accused him of racism because he was in government at this time and he actively opposed the Civil Rights Act. He was opposed to the busing of black students, to racial integration. And so again, these topics still create debate. But even after the Civil Rights Act, things aren't solved. We still have the voting barriers. So you get the Voting Rights Act of the same year, much later. And the Voting Rights Act basically is going to outlaw literacy tests. And you're also going to get the 24th Amendment, which bans poll taxes. And so finally, after the 24th Amendment and the Voting Rights Act in 1965, we've gotten rid of Jim Crow. We've gotten rid of literacy tests and poll taxes. We've gotten rid of the racial segregation of both public and private schools, as well as businesses and public gathering places. But what's left? Well, that's for you to determine. The exact extent to which we have made progress in the racial arena is still a contentious topic. And I'll leave that for you to work out in your discussion boards.